Well, hello everybody, and welcome to our conference on autism. Hope everybody had a good spring break. Here we are in March of 26, and hopefully you're all refreshed and ready to go for the rest of the year. And that'll come faster than we know it. It always seems to this time of year. I'm William Buechler on behalf of the National Educators Law Institute and Buechler & Associates PC. My topic today is to do the year in review. We're going to talk about some more interesting cases from the past year. I'm going to refresh us on the latest U.S. Supreme Court case dealing with IDEA. We're going to talk about some Fifth Circuit cases and then federal district court case that just came out recently within about the last 10 days or so. So we're going to get to that as we go through our review. Again, it's March of 2026, so a lot of these cases that we're talking about will be over the last year. We'll go back into 2025. So where are we so far in 2026? Let's take a look. Well, we all have new legislation, as you know. I think last time we did a similar presentation, we talked about the legislative session that was coming up. Well, they've come and gone. Most of the new laws affecting school districts went into effect as of September 1st of 2025. And as you all know, the legislation was really heavy on parental issues this year, parental rights. We had the voucher system put into place, which we'll be dealing with next year. Of course, we had the cell phone ban in schools, which as of March of 2026, most people can agree that that's been a pretty positive piece of legislation. We had the 10 Commandments displays. That's caught in litigation. It's up at the U.S. Court of Appeals for the Fifth Circuit right now. We have the ban on DEI, and we have those kind of things going on. So we're in our first year of this new legislative, these new laws that are affecting schools, the changes to the education code. Discipline was another area, and grievances were other areas that were affected quite significantly by these new legislative changes. So we're dealing with that now. We also have changes at the Department of Education. A year ago, we got a new administration, and of course, when the new administration went into place, the focus was to downsize or eliminate components of the Department of Education. Some advocate for just total banishment of the department. That hasn't happened as of today, but there have been some pretty significant changes as things are starting to go into different departments. Special education funding was one of those issues, and it's my understanding the DOE will continue in that regard. One area that does affect the kids with disabilities some, though, has been the Office for Civil Rights. As you know, a lot of those offices combined. We used to have an office in Dallas that covered us in Texas. That is now, I believe, in Kansas City. It's been subsumed by that branch up there. So those kinds of complaints are moving very, very slowly right now. So we don't see a whole lot in the way of OCR determinations. That has gone back to some of these cases from several years ago, where the investigators are picking those up and moving forward on those. But anyway, that's one area where the train is pretty much stopped at the station and hasn't left. So we'll see how those phases work moving forward, and see if the midterms have changed any of that. We don't really know at this point, but we can see. Then, of course, we have our new cases. So there's primarily 5 cases I'm going to talk about today. I'm going to review the Andrew F. case, which is the U.S. Supreme Court case. I think it was from 2017, but that's a U.S. Supreme Court case, and we follow the standards that were put in that. So anything else that we deal with, whether it's a hearing officer, whether it's a federal district court, whether it's a court of appeals, they have to follow the Andrew F. dictates. So we'll just review that so we understand what's happening in these other cases. I'm going to focus on the autism cases, since this is a autism conference, but there are a couple of these cases which I think are somewhat significant, even though they might not be related to autism. But we do have a couple that just came out, one in late 2025, and then just kind of an interesting order on an injunction case in early 2026 that deal with kids with autism. So we'll go over that. Okay, so first of all, let's just review our hierarchy of legal authority when we're dealing with SPED cases. Of course, our highest court of the land constitutionally is the United States Supreme Court. The Supreme Court justices are all appointed for life, and just like everything else in politics now, where a lot of people are divided, people are very divided over the Supreme Court justices and whether they should stay on the court, whether they should move on. But anyway, there's 9 of them up there, lifetime appointments. They're appointed by the president. Of course, their decisions are binding on all federal and state courts. The U.S. Supreme Court interprets the U.S. Constitution and all the federal laws. So that's, and regulations. So that's going to include everything we deal with under special education, IDEA, under 504, under ADA, under Title IX. They're going to be the highest authority in the land. And it's important, as I mentioned in the Andrew F. case, is that all the other U.S. district courts, administrative agencies, federal courts of appeal, they're all bound by that decision. So when the U.S. Supreme Court comes out with a standard for something, and of course for years we worked off the Raleigh standard, but now it's the Andrew F. Standard, everybody has to follow that when you're interpreting whether a child is receiving a free and appropriate public education. Then we have our federal courts of appeals. They're binding on all the federal district courts in the same circuit. So we are bound by the decisions of the U.S. Court of Appeals for the Fifth Circuit, which is headquartered in New Orleans. That covers Texas, Louisiana, Mississippi, and a couple of the U.S. provinces. Very persuasive court out there, and fairly conservative court overall. But those decisions, so when I talk about a Fifth Circuit decision, that's going to be binding on all of us in Texas, our Texas special education hearing officers, our federal district courts in Texas. So no matter where you are in the state, if the case is in front of a district court or an administrative hearing officer or due process hearing officer, we're going to be bound by what the Fifth Circuit said. Then we have all of our U.S. district courts. These are our trial level federal courts around the state. So they're the ones that hear the evidence, okay? And if it's a jury trial, the jury decides. If it's a bench trial, the judge decides. And then that appellate case can be taken to the U.S. Court of Appeals. So the trial courts are the ones where they hear the evidence, they take all the exhibits, and make the initial decisions normally. So those decisions are only going to be binding on the parties to the case. So it's a school district and a parent. A decision by a U.S. District Court, for example, in the Northern District of Texas, is only going to be binding on those parties. Now, it may serve as what we call in the law persuasive authority to other courts, particularly within the same district. So let's say we have a federal judge in Austin, which is the Western District of Texas, make a determination and like a stay put thing that's never been addressed before. That is an initial impression of law, and it might be persuasive. In other words, like a federal judge in San Antonio or El Paso, which are also within the Western District, may look to that as authority, but they're not bound by it. They're not bound by it. So we have 4 districts that are just divided up geographically when your school districts, where your school district falls within one of those districts: east, west, north, and south. And then, of course, most cases are handled at the administrative level, the administrative agency determinations. So in Texas, of course, when we're dealing with Fed cases, it's going to be TEA, our independent hearing officers, the Texas Education Agency. We also have OSEP and we have OCR. I already briefly talked about OCR and where OCR stands with everything in terms of their operations and their consolidation of offices. Again, similar to U.S. District Courts, those are binding only on the parties involved and within the agency's regulatory authority. So for example, if a parent files with TEA, and some of you have been through this before, saying my child was denied FAPE, also the school district violated FERPA, also this employee needs to be fired for the actions towards my kid, okay, those are, TEA only has limited jurisdiction. They can only hear the idea part of that. They don't have jurisdiction to decide FERPA issues, and the agency doesn't have jurisdiction to decide issues with respect to employment, okay? So they're very limited on their jurisdiction, which is set by statute, and they're binding on the parties only. Sometimes they're considered persuasive authority by courts. If it's an issue of first impression, perhaps a court will look at it on a review and say, I agree with the hearing officer on that, but that's generally not the case. They're not bound by any administrative agency. They are subject to what's called a de novo review by federal courts. De novo just means new. So basically, although you might have all the evidence in front of your hearing officer in a due process case, that will go up to the federal court. The federal court does not give any type of precedent or authority to the hearing officer's fact findings and conclusions of law. It's called a mixed de novo review. So in other words, they just review it like it hadn't been heard before. Now, of course, a hearing officer would be the one to judge credibility and that kind of thing, but a judge is not bound by the findings of the hearing officer, although they do a lot of times because they're not the fact finder in that circumstance. So that's our basic hierarchy of legal authority when we're dealing with special ed cases. So now examples in the special education context. A Fifth Circuit, as I stated before, a Fifth Circuit ruling on IDEA is binding on all Texas district courts. The Texas District Court decision on a SPED claim may guide other Texas judges, but it's not necessarily binding. And then a state hearing officer's IDEA decision is reviewable and not binding in other cases. And it's kind of hard nowadays, really, with the hearing officer decisions. If you've ever looked at those, they're on the TEA website, but you know, and it's fine for confidentiality purposes, but sometimes they're so whitewashed in terms of being redacted that it's hard to really understand what's going on. So a lot of times they don't even state what the child's disability might be. So it's hard to take something, unless you were involved in the case, you just look at it and say, okay, this is an autism case. Therefore, this law kind of applies because the student is autistic. They might not even say that in there. So those are getting harder and harder to use as any kind of authority or teaching instrument, because we don't even know all the background because of the reaction that occurs. And again, that's fine that happens, but it's harder to interpret what the meaning is out of any specific special ed case. The appellate court reviews that we have determined, there's different ways courts are going to look at this stuff. Appellate court normally is the reviewing court, so the complete record is in front of that court. They might have oral argument, like the Fifth Circuit will have oral argument on something, but they don't hear witnesses and they don't take additional evidence like expert testimony or exhibits, okay? So for the most part, an appellate court is just going to review what the district court decided and the record that was there and make a determination whether the law was appropriately followed. Sometimes the appellate court will review motions made on summary judgment or motion to dismiss. Those are just procedural components that are used to get rid of a case before there is a full evidentiary hearing. So a summary judgment might be used just as a matter of law. The plaintiff can't bring that type of lawsuit. So example, like I said on like FERPA before, if it's an IDEA claim and they're claiming violations of FERPA, that's a different privacy statute, and you can get a summary judgment on that because that's not an IDEA type claim. So you don't have to go to the merits, you don't have to get to all the facts and all the witnesses and the exhibits, because as a matter of law, a court can't hear that. De novo review I already discussed. That's when the court just reviews everything. Again, they're not seeing additional evidence generally, but they're reviewing what's already there. And in federal district courts can add on these special ed cases, they can add additional evidence at the request of the parties. Sometimes they just go off the record, and sometimes there is additional information used. Injunctive relief is a little different. You see claims for injunctive relief, and usually injunctive relief comes into play when waiting for the merits to play out just won't work, usually for like monetary damages. So as y'all know, sometimes a case when it is filed in a district court might take years to get to a jury or to get to the judge or to get a decision. Well, sometimes the parties just don't have that long to wait. So for example, if there's going to be development in a city and it involves taking down a forest, if the forest is taken down and then years later the court or a jury says, yes, it was wrong, they didn't get the proper permits, there was an endangered species there or something. If this forest has already been torn down, then it's kind of irrelevant to go for damages later on. So a party might file for injunctive relief to put a stop. So it's really when monetary damages don't work that injunctive relief might come into play. There usually has to be some level of imminent harm, and the person asking for the injunctive relief has to show that there's a substantial likelihood of relief on the merits. So in our SPED situation, it might be on a discipline situation where you get a very dangerous kid. And in fact, the law allows that now for us to seek an injunction where we can't go through a full due process hearing if the kid is injuring or poses a threat of harm to other students or staff members. We might have to go to court and get an injunction which would order a specific type of placement pending a case on the merits. Because waiting until the merits isn't going to work because the kid might injure someone in between. So you need to move on those a little faster. So again, the general appellate court review is going to be just looking at the record and making a determination on the law. But then we have these other procedural devices that may be used. Okay, so before we get into our Fifth Circuit cases, remember Andrew F. Andrew F. was the U.S. Supreme Court case from, I think it was around 2017. It's Andrew F. Versus Douglas County Schools. And basically that took the Raleigh standard and just enunciated some new standards and guidelines. So Raleigh is the case that was from 1982 that basically said a free appropriate public education is where a child has to get educational benefit. That's what the statute requires. That's the definition of a FAPE. In the Andrew F. case, the Supreme Court came back, relooked at Raleigh, tweaked it a little bit, and kind of moved on from there. So before we get into these Fifth Circuit situations, let's look at what lurks with Andrew F., because that's what courts are always going to be looking at. So what the standard is, they said an IEP must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Okay, so that wasn't a great change from the Raleigh standard, but that's basically it. So when we're looking at a kid's IEP, when you're looking at it in an ARD meeting, when we're looking at it as in a mediation or a complaint, is it reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances? And we'll talk about what that means in a second. So before that, before Andrew F., what a lot of courts just said was a more than de minimis standard. Okay, more than de minimis means that more than just a minimal standard. And again, we all know in these special ed cases, they're very fact specific. And as you'll see in the Northeast case that we're going to talk about in a minute, the courts are looking at kind of a holistic approach at this. So what is that standard? What kind of progress? When we talk progress appropriate in light of the child's circumstances, before Andrew F., it was just kind of tipping the scale a little bit. That would be more than de minimis, but the Supreme Court kind of rejected that. So that's a little too low. That standard's a little too low. So the student's progress must be more than trivial and appropriately ambitious given the student's needs. So I love how these courts come up with these kind of guidelines for us. And sometimes they're intentionally vague, so courts can go back, apply the facts in any given circumstance, because it's hard for a court, particularly at the level like at the U.S. Supreme Court, to create a standard that's going to work for every situation. So you could look at a student with an intellectual disability or OHI because ADHD, but from an academic standpoint would be fine, but we have behavioral issues. Or the opposite, we're looking at just an academic standpoint. So there's a lot that goes into academic and non-academic progress that we need to be looking at when we analyze our cases on this. So the court said with the progress that the kid makes, it has to be more than trivial, but not ideal. I think that's been there for decades and decades. It doesn't have to be ideal. It doesn't have to be perfect. I'm talking about the IEP and the progress that the kid makes. It just has to be appropriately ambitious given the student's needs. Again, as always in these cases, we have to focus on the unique needs of the student. Okay, so what else we got? The progress must be ambitious but realistic. And I like the way the court came forward with that. Must be ambitious but realistic. For students in Gen Ed, progress towards grade level standards will suffice. So that goes back to Raleigh. That's pretty much been it. So if a kid can, with the IEP in place, make progress by passing marks and going from grade level to grade level to the next grade level, that is generally, from the academic standpoint, has been viewed as ambitious and realistic progress, okay? The complications come up, and Andrew really addressed this, and Northeast addresses some, but for students with more behavioral-based disabilities, the district must show progress more in functional and behavioral areas, okay? So that one's a little more difficult. Keep in mind on this stuff. So in the Supreme Court in Andrews said this. You know, they basically stated that courts will show deference to schools, but not blind deference. And I like the way that we put that. So the courts recognize, and I mean courts, this is anywhere from hearing officers up to the U.S. Supreme Court, they recognize that the educators are the experts, or the educational experts, okay? So they'll show deference, but not blind deference. So courts will defer to educators when the decisions are reasoned, based on data and expertise, data being a key word in there, okay? So when the decisions are well-reasoned and based on data and expertise, generally, if it's a toss-up, the courts will go back to the schools and say, you are the professionals, you have the expertise, you have the data to back up your decisions, then that's going to be an argument that usually the school wins. That's why we always talk about in any context is that you got to have data to back things up. The PLAPs, you got to have where the child is in any current time. Are the goals working? What's the data to support the progress on the goals and objectives? So that is always has been an important component. In Andrew F, they specifically just outline that. So how do we apply Andrew F? First of all, you got to be careful about using generic or form documents. I don't mean, I know you'll have form documents for your IEPs and the software and all that. I don't mean that. I just mean having something that's just generic or a form that every kid has access to. The problem with that, it's not necessarily individualized to a kid's needs. If we do have a form document, we need to look at what the kid's abilities are, and we need to make sure that it is individualized to that child's individual needs. Of course, we do this through, at the beginning of our meetings, identify the child's current academic and functional performance. And this is where we get into problems. So again, this doesn't happen all the time, but it does happen when there are allegations, whether it's a SPED complaint or a due process hearing, when we're just repeating goals year to year. So sometimes we're like, well, we'll continue the goal to next year. We've got to be careful, because that's one area when we're applying Andrew F, that progress, if there's not meaningful progress, or that progress is just stalled out, as long as we're looking at the goals and we're approaching that as, okay, we need to lessen it, we need to change it, we need to increase something, as long as we're looking at that and not just the same goals over and over again. And I say from year to year, but also even within the annual year, I mean, if it's stalled or it's not, the kid isn't making meaningful progress, we need to be looking at that. And I understand again that that's very fact specific and to specific kids and specific disabilities, but that is a way where under Andrew F, they'll say the child isn't making meaningful progress. So when I talked about that deference, but not blind deference, what the court said in Andrew specifically says schools must be able to provide cogent and responsive explanations. And I like they said cogent and responsive. So it's logical and convincing. So you gotta to have that cogent and responsive explanation to what our goals are and whether the child is making progress. You got to consider all performance areas beyond academics. It might be communication, it might be behavior, it might be some other components. So academics are extremely important, obviously, but that doesn't apply to every student. Sometimes it is progress just on communication, it's progress on a functional skill, progress on a behavioral component, okay? So you got to consider all of those areas, and we have to monitor and adjust those goals as necessary, okay? So we need to make sure that the IP is appropriately ambitious. So what does appropriately ambitious mean? Again, for academics, advancing from grade to grade will generally suffice. But if grade level advancement is not realistic, then we have to meet some other kinds of challenging, is the way the Corps put it, objectives, okay? Because we know a lot of the students that we deal with, grade level advancement isn't going to be realistic. That's an easier one to analyze in terms of, okay, yes, the kid is moving grade to grade, but that's not always going to be the same. So our goals in the IP must be challenging based on that kid's unique levels. So goals should try to close the gap. Obviously, remediation isn't something that's not something that's required under IDEA, nor should it be. But we're closing the gap as opposed to maybe meaning 100% of the curriculum, as you know, maybe it's going to be 60% or 65% or 70%. So at least the kid is making some level of goal in closing that gap a little bit, although they're never going to be at the 100%. That would be appropriately ambitious based on that child's individual needs. Okay, so ambition is measured by whether the goals are challenging, whether they're measurable and attainable through appropriate interventions, and of course, research-based instruction. So research-based instruction is very important. To give you an example where that all went awry, there was a recent special ed complaint where they dismissed a kid from special education, and they didn't really have the data to back it up. The kid had been doing pretty well, but they didn't do additional evaluation. And even the special ed coordinator basically just said, no, it was a girl who's is regressing. But the committee went through and they ended up dismissing the kid from special ed. Well, that went through the complaint process, and the state agency found against them, of course, because they didn't have the appropriate data. They didn't have the cogent reasoning. You couldn't give the school district deference because they didn't have the data to back it up. It wasn't research-based instruction, and again, it seems unlikely, but those kind of things are happening up there. So, you know, if you just follow what our requirements are, we should be in pretty good shape. Okay, so that's kind of where Andrew F is. Let's look at some of these cases now. So Northeast ISD versus IM, that came out in late 2025. And this is from the U.S. Court of Appeals for the Fifth Circuit. Let's get some of the background facts. So we have IM, and he's an elementary student he's got a speech impediment, he's autistic, and an intellectual disability. IM struggles to communicate. He's got a lot of disruptive behaviors, but the two behaviors that were most prominent with him was persistent toileting issues and frequent elopes from school. And in the record that was there, that was made in front of the hearing officer, there was a situation where he did endanger himself, where he came back to school, eloped, and actually bystanders had to catch him. It was a busy road that he had no kind of concept of, with cars coming by, ran through the road. Bystanders had to hold on to him until the principal basically went and retrieved him, and this was about a 30-minute process. So obviously, you know, eloping with IM was a serious issue. So it really came down initially at ESY. He was a little elementary guy, and when this case started, he was in second grade. The district did provide ESY services, but when he would come back, he would continue to show regression in basically toileting and the elopement, okay? So what would occur is that he was actually showing improvement under the IEP through the year. So second grade had the standard ESY of the half day for the 4 weeks. The school district did not provide any more. When he came back, he did have significant regression at the beginning. He'd have a lot of elopement and toileting issues. It would even out, and then in his 3rd grade year than his 4th grade year, he actually did better on the elopement and the toileting issues on the IEP and on the goals. And importantly, he also did very well. The school did well with him academically. The problem was during the break times, whether it was the summer or the holidays, the kid would go through, IM would go through pretty significant regression if they didn't stay with it. So at one of the art meetings, I think he was going in from 2nd to 3rd grade year, the district increased ESY, but did not provide a full summer program. The parent wanted a full program all the way through. So when ESY ended in June, when the kid came back in August, that's when all this regression was there, even though the subsequent year, school year, the kid did do better on those goals. So the school district increased it from 4 weeks to 6 weeks, and that did show some improvement. But then on his 4th grade year, the first 2 weeks of the 4th grade year, he eloped multiple times. And this is where, again, sometimes the facts, they get a little serious. So they include one instance where he crossed a busy road, and that's where he stopped by bystanders. I talked about, and it was about a 30-minute process. And luckily, nobody was hurt from the thing, but that was at the beginning after coming back. So the parent requested additional ESY services over the summer and other breaks, but the school didn't grant that request. In other words, the parent pretty much wanted this kind of a seamless summer program as opposed to ESY that was generally offered by the school. The school did not grant that request, although they did do the 6 weeks. Okay, so this went to a hearing officer. The parent requested a due process hearing, asked for ESY services for all breaks, a GPS tracking device, and an IEP goal for safe bus riding. The hearing officer ruled for the parent, and then when the district appealed it to district court, it affirmed the hearing officer's findings, and the school appealed to the 5th Circuit. So the 5th Circuit, what happened there? So there, the school argued that the district court improperly focused on disability remediation rather than the appropriate ESY standards. So the way the wording of the district court's ruling was more like try to remediate the elopement and the toileting issues rather than what is ESY, of course, with respect to significant regression and then the 8 weeks and all that type of thing. But the 5th Circuit didn't take that argument. 5th Circuit found that the district knew that the student regressed over breaks, including the toileting and elopement. So the court found that the student's elopements were a present grave danger that required more from the school than what his IEP provided. On the respect to the remediation argument, the 5th Circuit found that the district court's review holistic and not remediation focused, and reiterated that academic progress is relevant but not controlling. So holistic meaning that it looked at non-academic, academic benefits, and it was clear that the 5th Circuit agreed and the district court agreed the kid made academic progress. That wasn't an issue. In fact, they used the word laudable as far as academic progress was concerned, but they said that that academic progress, although relevant to the issues, is not a controlling issue. So in Texas, and under the 5th Circuit, we have almost a 30-year-old case. It's Michael F. versus, or Cypher versus Michael F., where we looked at the 4 factors. And just to paraphrase, is the IEP individualized? Is it in the least restricted environment? Were the key stakeholders involved? And did it demonstrate academic and non-academic benefits? So the court was looking at the 1st and the 4th factor on this one. And again, the court indicated academic progress is relevant but not controlling. The court also looked at the fact that the kid actually did better on toileting and on the elopement over the 2nd, 3rd, and 4th grade periods. That every year went better, but they said the problem is that because of the after the breaks, how the kid would regress, it was a present and grave danger, and that was really the primary issue that made this made the 5th Circuit affirm the district court's determination against the school district. So again, the court stated that the district made a laudable effort to ensure that IM progressed academically, but the students' behavioral issues were uniquely severe. So what do we learn from that? We need to be sure that even if the child is making progress academically, you're looking at the big picture. This was more of a ESY type of situation, but it's one to be aware of. The school district was aware, they were working in the right direction. They had a lot in place for the toileting and elopement. So not to say that there wasn't something in place. They had a lot in place. They had a BIP in place, and they had different interventions that were there. And essentially, but the problem was after these breaks, and it wasn't seamless. In fact, the school had offered in-home training that the parent did not want. So, I mean, there's, you know, there were many laudable things that the school district did in this case. So, again, the court emphasized that academic success alone is not sufficient to constitute FAPE. Holistic analysis is appropriate. Progress in academics does not compensate for failure to address critical behavioral needs. So keep that one in mind. The other thing to keep in mind too is the Fifth Circuit reviewed this case on a clear error standard. And a clear error, when you're appealing a case at the Court of Appeals and asking for a case to be reversed, clear error is a very difficult thing to meet, because, you know, the Fifth Circuit can say that the Fifth Circuit standard is they have to look at a finding of fact by the lower court and say there was a definitive and firm conviction that the district court was mistaken. And it's very rare for a court to do that unless it's something very obvious in the record. And even if there's like two permissible views of the way to look at evidence, then the Fifth Circuit can't reverse a district court unless there was clear error on that. So the fact that there was two ways to look at evidence, even though the Fifth Circuit may have gone a different way on that, they can't reverse a district court if it was just a matter of interpretation of that evidence. So anyway, I thought that was critical that the Fifth Circuit even just put in there that, you know, it was a clear error standard, and they did say the district's actions were laudatory as far as the academic concerns were, but that it was the behavioral issues just kind of overrode that in this circumstance. So that was from the fall of 2025. Well, it just came out on March 13th. This was an order. It's not a full decision. It's Weatherford ISD versus KL. This is a U.S. District Court out of the Northern District of Texas, and it's on a preliminary order. So there's a hearing officer decision, but it's not up yet, so I can't really analyze it. But what we have in this Weatherford case, we have KL. KL is a 17-year-old, has autism, ODD, disruptive mood dysregulation disorder, and ADHD. So there's a lot of things going on here. The KL had a history of property destruction, verbal and physical aggression, self-harm, elopement, and non-compliance. So we don't have all the facts here, but the kid did leave Weatherford, went to other districts, and was coming back. Weatherford was the home district, but the parent requested a due process hearing and an order placing the student as a residential facility at the district's expense. Okay, so as you know, these are usually in special ed, we don't get into really high monetary type cases. These residential placement cases can certainly cost the district a lot of money if it doesn't go right. So the parent requested due process, an order placing the student as a residential facility at the district's expense. So at the time of the hearing, the student was at the Texas State Hospital here in Austin, which falls under Austin ISD's jurisdiction. So the hearing officer ruled for the parents in order a residential placement at the CALO programs, which is in Missouri, or another or other suitable program for a one-year period. Okay, so they went through due process. The hearing officer ruled for the parents, ordered a residential placement at the CALO programs in Missouri, or other suitable program for 1 year. So at the time, again, remember the kid's at Texas State Hospital in Austin. Hearing officer orders the CALO program in Missouri. So the school district has appealed this case. Now, just clear for at this point, there's been nothing on the merits, so I don't know what's going to happen at the federal district court. But from a procedural standpoint, what happened is both sides are looking for an injunction. So the district appealed the decision to federal district court. Again, that can take some time, but from a procedural standpoint, both parties, both the school district and the parents, sought a temporary restraining order and preliminary injunction over what was the stay put issue in this case. So the parent won at the district court, at the hearing officer level. The kid is at the Texas State School. The question is, pending this appeal in federal district court, what would be the proper stay put placement? So the district argued that the student should stay at the Austin State Hospital pending the proceedings. Say that Cal would cost the district approximately $500,000 based on that order. The parent argued that the state, through the due process decision, which is kind of set forth in the regulations, had agreed with the parent that Cal was the stay put placement. So the question is, where do we go from here? Well, the district court denied both of those motions, which effectively kept the stay put placement at the Austin State Hospital. So as far as the decision was concerned, basically it said it denied the parent's motion because there wasn't enough in the briefing to show. Remember before I talked about an injunction, likely a substantial likelihood of success on the merits, imminent harm. They said that he was at the Austin State Hospital that did not meet the criteria for an injunction. So the court denied the injunction as far as the parent's request is concerned, and then denied the injunction as far as the school was concerned because they said, the judge said, since he was at Austin State Hospital and that they did not grant the parent's request for an injunction at Cal, then the Austin State Hospital would essentially be where they're at. So again, that was not that long ago. It was just literally from the time I'm recording this a little bit, around 10 days or so ago. So we'll see where that ends up. But I thought that was kind of interesting on kind of autism and severe behavior. First of all, we'll have to see what happens on that appeal, whether the hearing officer's decision stays, which granted that residential placement in Missouri, and what happens in interim. But again, those are preliminary motions. The subject to change. There's not a lot of facts in that motion, but that's kind of where we are at this point. So that was fairly recent. That was a federal district court in Northern District of Texas. The next one we have, this is it's basically exactly a year before that Weatherford order came out, RW versus Clear Creek ISD. That was from the 5th Circuit, March 13th of 2025. This is kind of an interesting background on this one too. So RW had traumatic brain injury at birth, and it resulted in cortical visual impairment. Okay, so it's an important fact that traumatic brain injury at birth had CVI. CVI is a brain-based form of visual impairment as opposed to an eye-based form. So what happened during the 2021 school year, the student's IEP focused on the use of Braille instead of vision goals. So an expert in CVI made recommendations about how the school district could better facilitate RW's functional vision. The district made some changes to the IEP, but his parents were dissatisfied and requested a due process hearing. Okay, so they had an expert make some recommendations. The parents weren't happy with those recommendations, and therefore the parents filed for a due process hearing. So what happens here? The hearing officer determined that the district denied FAPE and that his vision services were not reasonably calculated to confer an educational benefit. Okay, so the hearing officer finds for the student and the parent. Said the school district denied FAPE because the vision services proposed by the school district were not proper. Then the hearing officer goes on to give the specific orders in the case. Said, school, you must retain a consultant with expertise in CVI to supervise the development and implementation of the IEP. So we must retain a consultant with expertise in CVI to supervise the development and implementation. Have the consultant meet with the student's teachers at various times. Arrange for the consultant to test RW and discuss the results at the next annual meeting. Have the consultant train the staff on CBI and schedule a meeting to revise the IP consistent with the consultant's recommendations. So you can see it's fairly specific, but not real specific. So it doesn't have a bunch of time frames on it. It just says the school has to retain the consultant with expertise, supervise the development implementation of RW's IP, has to meet with the students, teachers at various times, arrange for the consultant to test and discuss the results at the next annual meeting, have the consultant train the staff, and then schedule a meeting to revise the IP consistent with the recommendations. Doesn't say this is supposed to go on for a couple of years, 2-3 years. It's basically kind of self-contained within a somewhat short period of time here. So what happens? The school district, they go ahead and they follow this. They contracted with a CBI consultant, provided some training to its employees, but did not follow all the consultant's recommendations and chose not to pay for additional training or services beyond the 22-23 school year. But when you look at that order, it didn't say that they had to provide additional training or services beyond beyond that current school year. Okay. Also, it says it didn't say you have to follow all of the consultant's recommendations. Okay, just that the consultant had to be involved and supervise stuff. So they did provide training. They did follow some of the consultant's recommendations, but not all of them. So, and then, and I think that's an important point, TEA oversees the implementation of the hearing officer's decisions. It did conclude that the full school had fully implemented the hearing officer's order. I think that's a critical component on that. So what happened is the parents sued under special education, under IDEA, Section 1983 and Section 504. The district court dismissed the claims, and the Fifth Circuit affirmed the district court's decisions on this. So it's interesting, you know, we have all these protections that we have under the special education, but Section 1983 is where you can bring constitutional claims, or Section 504, of course, is our it's a statute that deals with anti-discrimination statute. We have to show some level of intentional discrimination. So what did the court do? So the court found as follows. The student lacked standing under IDEA because he was not an aggrieved party since he wanted the due process hearing. So it's an interesting component. If you go back to that due process hearing, the student and the parent won. So the old saying is you can't take yes for an answer. So they won and they got the relief that they were seeking. So under IDEA, you can only appeal a hearing officer's determination if you are an aggrieved party. And the court said, the Fifth Circuit said, since they wanted due process, they're not an aggrieved party. So they said under special education law, the student and the parent didn't have any standing. So they dismissed the IDEA case. Then you get to Section 1983 and Section 504, and what they said that the district court had properly dismissed those since it didn't rise to the level of intentional discrimination. Okay, it's higher than deliberate indifference. So it's intentional discrimination is something where you would, like, for example, you would refuse to implement accommodations. In this instance, they said the parties just had disagreements over the consultant and how the program would proceed and how the training would proceed subsequently. But in essence, a disagreement is not the same thing as intentional discrimination. And the fact that TEA said, well, the school district had fully implemented the hearing officer's decision, that pretty much negated any context of intentional discrimination. So refusal to implement accommodations. Another example of intentional discrimination based on those facts is that they refused to let the CBI expert do training, or if they did not follow any of the CBI experts' recommendations. That would be a deliberate indifference or intentional discrimination because you're just ignoring what the hearing officer ordered. But that's not what they had. They just had disagreements over that. So I thought that was an interesting case because from an IDEA perspective, since they won, they were not aggrieved, so they cut out any of the special ed claims. And then on the intentional discrimination claims, it's just basic disagreements are not going to rise to the level of intentional discrimination. It's like negligence or something along those lines. That's not going to rise to the level of intentional discrimination. So I thought that was a very interesting case. And then our last one is EJ versus Eagle Mountain Saginaw ISD. This was from the Northern District of Texas, goes back a little bit into 25, January 30th of 2025. This was kind of an interesting one because we'll see how it is with respect to private school placements, what the expectations are there, and how that's balanced out, and the school's efforts to review the school, make the determination as to the least restrictive environment. I talked about the Cypher versus Michael F factors. One of them is least restrictive environment, and that certainly came into play in this case. So DJ qualified for SPED, ID, SI, and OHI. Okay, so he had a history of physicality with other students, and when he went into high school, that kind of escalated. The school district worked with it, and eventually his behavior did improve some. And throughout the process on the evaluations in his IEPs, the parent had always agreed to everything. But in the spring of 2022 at his annual ART, you notice on a lot of these cases, we go back to 21, 22 or so, even though we're talking about 25 and 26, because that's how justice works sometimes. It takes a while to get through the hearing officer process, the district court process, and then up through the Court of Appeals. But anyway, at his annual ART in the spring of 22, the parent agreed with the results of the re-eval in the IEP, including the BIP, which is important for this one. On the same day, however, the parent withdrew the student and enrolled him in a neighboring school district. Now, in his 12 years at EMS, this DJ had always received special transportation. Okay? So for all that time at EMS, he had always received special education, and that wasn't, special transportation, that wasn't in dispute. But since he was not enrolled in EMS at the start of the 2023 school year, the father brought him to Saginaw High School on the first day of school, which is in EMS. Since he was not enrolled, obviously special transportation had not been arranged, right? So of course, when things happen like that, it always happens around the first day of school, right? Particularly transportation, things blow up. So the diagnostician on the case immediately informed the transportation department, told dad that it would take several days to set up a route. He informed the father, the diagnostician informed the father not to use general ed bus stop. Okay, so what happens? Of course, despite knowing this, dad left the student at the general ed bus stop. That morning, now remember the behavioral issues we had with the kid. That morning, while waiting for the bus, the student crossed the street, used a racial slur against a female student. When he was approached, the student repeated the slur, slapped the girl's male friend, and engaged in a physical altercation. So, after 10 days, the student returned, but the parents transferred the student to a private school. Okay, so they sent him home. They worked on the transportation component, dealt with all the other components. There were a lot of issues in this thing. But the student returned, but the parent transferred the student to a private school. Okay, so remember he's 17 and we had his disabilities. The private school that the parent took him to had 12 students from elementary age to 26 years old. Of the 12 students, 11 had Down syndrome and the other was ID. The school held an ART, EMS held an ART and offered a revised BIP, which is always good in these circumstances when they move to a private school, get in there and address the situation. So they offered a revised BIP, counseling, psychological and counseling evaluations. The parent only sought reimbursement for the private placement, but did accept the evaluations. He further indicated that he would never return the student to the district. School personnel were not allowed to visit the private placement. So that's always one thing you want to do on these private placements, because we can almost always, from the public school perspective, offer the same thing or better, and particularly in the least restrictive environment, compared to what a private placement can offer. So the evaluation showed the student did not qualify for ED. Remember, they offered that, the parent accepted the ED evaluation. Regardless, the ART offered 20 minutes of counseling a week to deal with anxiety. The father refused the counseling and offered to attend other high schools in the district. So what was the court's decision? The hearing officer found for the school district on all issues and determined that the district's program provided the student with FAPE. The federal district court affirmed the decision of the hearing officer. again, going back to our 4 Michael F. factors, the court found the IP was individualized, addressed his aggressive behaviors, the evaluations were timely. The district offered the LRE by considering other high school placements, which was important because they've had other placements available and said we could do this program in one of our other high school placements where you don't have those other issues going on. But the parent chose the most restrictive route. By not working with the parent, particularly like the statement where the parent stated that he would never return the student to the district, the court found that the parent failed to coordinate in a collaborative manner with school personnel, and the student did receive academic progress through his IEP as he was making good progress prior to the placement at the private school. So in that circumstance, yes, the student was making progress through the IEP, academic progress, and behavioral progress. So that is just one situation that was favorable. Okay, so he's the issue with the private school, because remember they have to show that the private school is appropriate under IDEA. They have to show that it's essential for the kid to receive a meaningful educational benefit, and not or, it's and primarily oriented towards enabling the child to obtain an education. First of all, the court noted that the school personnel were not allowed to visit. He was placed in a classroom with non-disabled peers. He was 17 and the other students were almost all elementary and middle schoolers. The private school had no IEP or BIP, and the private school did not provide any speech, OT, or counseling. So you can see in that one, you know, the best way to go about that is, as I stated, you show that the school district's program that we can certainly match and do better. In this one, on all these 4 factors, the school's program was the best, from the least restrictive environment component to the fact that the private school didn't even have an IEP or BIP to deal with the students' academic issues or the behavioral issues. So, and they didn't have any of these other services. So, in that one, the school district won. So, that's it for the presentation. You can keep in mind that cases are always rolling off the press here, and we'll do it again. Hope you enjoyed the presentation and enjoy the rest of the conference and the topics. It's a good conference, lots of good topics in there. And thank you, and enjoy the rest of your spring, and may it all go well for you. Thank you.